Hello. Welcome to Discover a New Future, a show geared at empowering women to be the best versions of themselves. I'm your host, Faith Saunders. Well, a few weeks ago, we had Elizabeth Candido Petite. I said it correctly, didn't I?
Yes, you did.
Here, who is an attorney at Lindabury, McCormick, Estabrook, and Cooper. I did it right, too.
Yes.
Right. I'm bad with names, that's why so I just want to make sure. Right. And she's an estate planner attorney. That's what her area of expertise is. And the last time Elizabeth was here, we spoke about wills. And so this time when we're going to be speaking in more depth about power of attorneys, right? And I think as women, many of the time, we don't think about these things. It's like, we have to take care of our kids, we have all these things that we're doing, but these are not things that are top of mind, you know? They're not, these are things that are not a priority to us. But it's so important that we start paying attention to these things, especially if we have children. So, Elizabeth, thank you so much for coming back.
You're welcome. It's great to be here again.
Welcome. And for helping us to have a better understanding of what these different terms that we hear so often but have no clue what it means, giving us some clarity in terms of what they are. So I wanted, what is a power of attorney? Let's start that way.
So a power of attorney is a legal document that authorizes someone else who's either known as the attorney in fact or the agent, they're interchangeable, to act as if they were you with respect to your property, which means they can go to the bank and withdraw $500 from your account. Or they can sign the deed to sell your house or to buy your house. Or they can change the beneficiary designation on your life insurance policy. They can control your email account.
Now you see my look on my face, right? That's a lot of power that I'm giving away.
It can be a very powerful document, and there are certain circumstances where you need that.
Wow. So what are circumstances that you really
So the power of attorney, it's known as a lifetime document. This is only effective while you're alive.
Okay.
And I just read a statistic from a life insurance broker that 1 in 4 adults become disabled at some point during their lifetime. So, you know, you're alive, but for whatever reason you can't manage your property on your own. Maybe you got into a car accident, or you have a terminal illness, or you have dementia. You know, a lot of these things maybe affect you as you get older. So the power of attorney enables someone else to help you manage your property.
Okay. Wow, that's a lot of power to give away. Wow. So when does it come into effect then?
There are a couple different types of powers of attorney. The first type is known as a springing power, and that springs into action when something happens, which is usually, it's defined in the document, but usually it's if a doctor determines that you're incapacitated, which means that you're, for whatever the medical condition is underlying, you're unable to manage the property on your own.
Okay. All right. So what just came to mind?
Sure.
So I'm not able to make certain decisions. So who decides who becomes the power of attorney?
You do. You name. Well, no, this is so
Prior to.
Prior to.
Oh, okay.
Yes.
Okay. Sorry.
Yes. The power of attorney has to be signed while you're fully competent.
Okay. Okay. Okay.
Which is why it's important, even when you think, you know, you're invincible, to have it in place, because you won't always be invincible. And at that point, it's too late.
Okay. All right. All right. So all right. That's answer my question.
The other type of power of attorney is one that can become effective immediately after you sign it. And you might want to do that either if you're elderly and you just, you know, you need your daughter to help you care for your property because it's too much. You can't go to the bank every week like you used to. Or maybe you travel a lot for business and you want your spouse to be able to access accounts that you don't own jointly, or something of that nature, more of from a convenience standpoint. So because you give a lot of power, or you can give a lot of power, it's really important that you name someone that you trust.
So you're right. So that's a lot of power. So the question is, what legal framework is there to protect me? Although I may think that this person is trustworthy, but they're not. After giving them my power, giving my power away, they're not turning out to be as trustworthy as I thought that they would be. What are some of the
What can you do?
or that be or other people who
right.
are
If you're competent, you can withdraw the power of attorney.
Okay.
You can say, I don't want you acting anymore. Give it back. You can go to the bank and say, John can't talk to you anymore, or whatever the case may be, right? So that's one way you can revoke the power. Or what usually happens is that you're not able to do that, and family members get concerned that another family member or a friend or whoever you named as agent is taking advantage of you. And then the recourse they have would be to file an action in court.
Okay.
And then the judge gets involved and they have to examine what's been going on.
Okay. Okay. Wow. So
ideally, you don't ever want that to happen.
yes.
So,
Because it can be a long, drawn-out process, and by the time I don't have a penny to my name.
exactly.
You're right. So what happens to my property if I don't have if I don't? What happens if I don't have a power of attorney?
And you're unable to
To
manage your
manage it.
property, then you would have to have a court-appointed guardian. So again, back in court. And the guardianship proceeding, the court would appoint someone to sort of examine you to really confirm that you do need a power of attorney, or technically it would be a guardian to manage your property. And then that person would report to the court, and then the court would name a guardian. It could be a family member if there's one available. If you don't have a family member, or maybe your children are fighting over who should do it, and the court's like, well, this is not going to end well, they could appoint a third party to act as your guardian for you. And that guardian would have whatever powers that the court authorizes, generally the ones that I mentioned before, to manage your bank accounts, to manage your property, file your tax returns for you. If you were involved in any sort of litigation in court, they could act on your behalf in that litigation. The powers, in a sense, it's everything that you do on a daily basis that sometimes you don't even think about. And some of these things are just automatic. Think of all the automatic payments that you have. Mortgage, car insurance, kids' school tuition, or whatever. It just all gets taken care of. So that's what the power of attorney could take care of, or the guardian if it's a court-appointed guardian.
Wow. So interesting stuff. So, is there anything that I can put in place while I'm capable to prevent my property from being mismanaged?
The power of attorney is the best tool that you can use, because you have control over who's going to do it, who the agent is going to be, and what types of powers you give them. New Jersey doesn't have a statutory power of attorney like some states do, which means it's really up to you as the principal or as your attorney who guides you to decide which powers are included.
So can an attorney be a power of attorney?
It can. I don't really recommend it. I think that's putting a lot of sort of eggs in one basket, so to speak. The attorney, it sometimes creates a conflict for the attorney. Yeah. And especially if you just walked into my office and I didn't know you at all, then I wouldn't feel comfortable acting as your power of attorney.
Okay.
If you were my sister, then that's certainly a different story.
Right. Wow. You mentioned the different types of power of attorney. So almost anything that I would do in my life, I could have a power of attorney to do that.
Correct.
And that power of attorney, can I have more than one power of attorney?
You can, yes.
Okay.
You could name 2 or more powers of attorney at the same time, and you could either require that they all have to sign their name to do any function, or you can allow them to act separately. A lot of times aging parents might name both or more of their kids as agents and allow them to act separately, and maybe, I don't know, the son takes care of paying the house expenses and the daughter does the checking account or something like that, so they kind of divide and conquer. The other thing that everyone should do, I think, is name a backup. So you name, let's say your spouse as the agent, and then if something happens to your spouse, you name your sister or your child if your child is an adult and competent, or a family friend or something of that nature.
So it's similar to when we spoke about a will, that for the executor,
Yes.
that you have a number of different people lined up to take that person's place.
Right. Part of the exercise when you're doing estate planning of all types is, this sounds really morbid, but thinking of like all the worst case scenarios, you know? Well, if I die and my husband dies and my daughter dies, then what? And a lot of people get turned off by that. And, you know, I agree, it's not really a fun conversation to have, but it's important.
Right.
And I think it really helps a lot of people when they sit down and they go through that exercise.
Wow. Hard conversation. I think that's even one of the reasons why people don't have a will.
Right, because they don't want to have to think about those
Exactly.
decisions. But then what happens if you don't?
Right.
You know, I think that there's a much greater downside to not doing it.
Because, I mean, look at so many celebrities. You know, it's not about, I don't think it's about money why people don't do, most of the time don't do it. It's because it brings the reality close to home. You know, I'm going to die one of these days, you know.
Right.
So
I had a dear old lady client that I worked with several years ago, and every conversation that we had, she started with, well, on the off chance that something might happen to me and I might die or I'm not around. And I didn't have the heart to be like, it's not an off chance, it's going to happen.
hopefully she's still around. So we have an understanding of what the power of attorney is. So what is an advance directive now?
An advance directive is sort of the power of attorney's version for healthcare.
Okay.
So the advance directive names someone who can make healthcare decisions on your behalf. And so as I said, the power of attorney, you could make it effective immediately. And if you did that, then your agent could technically act even if you were fully competent. With the advance directive, if you're fully competent, you always have 100% say.
Okay.
No one, I mean, you can consult with people, but the doctor doesn't have to listen to them. They listen to you. So the advance directive only comes into play if you are disabled, if you're unable to make a decision.
Right.
So that could be, for example, you're unconscious, you get into a car accident, something along those lines, or maybe you have a terminal illness and you're in a coma, and the advance directive could authorize your agent to say, I think she had a good run, let's pull the plug. Yeah.
Right.
Which is, of course, never an easy thing to do, but again, a difficult but important conversation to have. You know, I think probably everyone should at some point sit down with their spouse or their close family members and say, you know, if this happens, pull the plug. But if this happens, you know, give me a little more fighting chance here.
And whatever that person's wish is, that's what has to. So if the person said, "Do not," what do you call it?
DNR.
DNR.
Do not resuscitate.
Yeah.
Right.
If the person says that I don't want that, every effort has to be made to preserve life.
Yes. Well, a DNR is a little bit different than an advance directive.
Okay.
So the advance directive is a legal document, and that authorizes someone to make the decisions for you and under what conditions. The DNR is a medical directive that the patient discusses with the doctor.
Okay.
And really that's to withhold CPR. So if you stop breathing, then the DNR alerts the medical team, don't do CPR, don't resuscitate.
Okay.
Just, you know, naturally let the person pass.
Okay. Oh, okay. Thank you for clarifying that. Yes. So talk a little bit more about the power of, not the power of attorney, the advance directive for me, in terms of what are some of the things can we put in an advance directive? To expand on it a little bit.
So, well, the one part that is pretty similar in everyone's is that you authorize someone to make the medical decisions if you can't do it. But then the other part, which is more of a typical living will part, is where you say, if this happens, then do this. And my firm has sort of our standard language that I think probably most attorneys use a variation of, which is if I'm unconscious, if I have a terminal illness, the doctors don't think I'm going to recover if I'm in a vegetative state, and I can only breathe with the help of a ventilator, those types of situations, then don't give me those life-sustaining measures. Make me comfortable, keep me pain-free, give me the pain meds, but don't keep me breathing artificially.
Okay.
But you can say whatever you want. And I've had some clients who pick through that with a fine-tooth comb, because they're like, well, if this happens, if I have a certain type of cancer, then pull the plug. But if I have another type, then I want every sort of experimental treatment that you can think of to be done on me to help me survive.
Okay.
So it's 100% personal preference.
Wow. Being an attorney, this is a lot of stuff. So, can I create a trust instead of a power of attorney?
Yes. Now, if you create a revocable trust, we had talked about that a little bit the
Can
last time I was
tell
here.
us again what that is?
So a revocable trust is a trust that you create, you're the grantor, and during your lifetime, or whatever the terms that you set, you can change it. You can revoke it, aka revocable. You can amend it, you can terminate it, and so you have full power as if it was your own assets. Usually it provides for your care, maybe for your spouse's care, your children's care, whatever your situation is, it'll cover that. And then it provides that upon your disability, the trustee, you'll name a successor trustee, because usually you're the first trustee, continues all those powers. So in that sense, it's the same as a power of attorney, because you're authorizing the trustee to manage your bank accounts, to manage whatever property is in the trust. And that's the caveat, because a lot of times people will go to the attorney and get a big fancy revocable trust, and they sign it, and then they say, okay, and they stick it in the drawer and they forget about it. Well, it only is effective for the property that's in it. So if you have a house and you want it to go into your revocable trust, you need to do a new deed. The title has to be changed from, John Smith to the John Smith Revocable Trust.
Interesting.
Or, whatever the case may be. So if you don't do that, then you're not taking full advantage of the revocable trust. And in that case, hopefully you have a power of attorney, which would then govern.
Right.
The benefit of having the revocable trust, especially if maybe you're elderly and you're starting to have some serious health issues that you think you might not be with it. You might be alive, but not mentally with it for too much longer. Is that the trustee has the power to act on the property in the trust continuously. So whereas if you had a power of attorney, the power of attorney ends with your life, which means then that property needs to get probated. You have to go to court. It's not a big deal, but it takes time. There are delays. The trust document names a trustee to take over immediately after you pass away, and then that trustee has the full power right away. So
we're talking about all these documents. So you recommend as an attorney that a person has a will, a trust, a power of attorney, an advance directive. It's a lot of stuff.
Well, to be honest, I don't think a trust is always necessary.
Okay.
It depends on your situation. It depends on your assets. If you're, I don't know, middle-aged and you own a house and a couple of bank accounts and a car and those sorts of things, and you're married, you have a couple of kids, unless you're going to do trusts for tax planning purposes, which is a different type of trust, you probably don't need a revocable trust. Some attorneys would disagree with me. Some would say you always need it. But here in New Jersey, the probate process is pretty simple. So there isn't a big lag time between when you die in terms of getting control of your assets. It's not that expensive. so it's a lot of times people in like Florida or California will put their property in a revocable trust to avoid probate, and it's not as important to do that here in New Jersey.
Wow. Okay. So, but you would recommend the power of attorney and the advance directive,
Yes,
though?
absolutely.
Okay.
So those two documents work during your lifetime. If something happens to you and you become disabled, or frankly, I mean, you know, people have medical procedures and they're otherwise perfectly healthy. You know, women can go to the hospital to give birth, and maybe they're unconscious at some point during the birth, and you know the doctor looks at the husband and says, "What do we do?"
That's true. That's true.
If you don't have an advance directive, then there is a statute that kind of gives an order as to who can make decisions. So maybe if you just have a spouse and you trust him or her to make the decisions for you, and you know that they're gonna their wishes are going to be honored, then that kind of takes the place of the advance directive. But I'd still say it's a good idea to have the document, because what if you're in a car accident together and your spouse can't act, and then, you know, your parents are feuding over what happens, or you have 3 sisters and they can't come to a decision. If you have an advance directive, then you decide who gets to make the call.
That makes sense, because so often, and I had a situation, family related, where a similar situation occurred. I don't think that there wasn't a power of attorney, but sometimes it's such a difficult decision. The person is, the quality of life that this person is living is not, you know, but nobody wants to be the one to say.
No one wants to be the one to say it, right? And sometimes these cases actually become public. You know, you see news stories about. I think there was one where something happened to the young woman, and she was married, and her father her spouse was arguing with her parents as to what do we do, because they didn't agree, and it became public, because the hospital gets put into an awkward position then, because you know their doctors are in the business of saving lives, and unless there's a clear directive that, you know. The person doesn't want it. Right. Then the hospital's going to do, for the most part, all they can to keep you alive.
Wow. These are, I mean, honestly, the 2 shows that I've done with you have really opened my eyes, you know, in terms of the importance of these documents. You know, again, time goes by when you're having fun. But, you know, what would you say to, because there are a lot of people my age, middle age, who may not even have any of these documents, you know? When do you start looking into these documents?
As early as you can, frankly. And I think the needs change at different stages in your life. Like I have a young family. I have a daughter who's almost 2 years old. So my primary concern is, if something happens to me, is she protected? My parents are probably closer to your age. Their concern is probably more along the lines of, if I get sick, if I have dementia, what happens to my property? Or even if I die, you know, who's going to serve as executor? Who of the children is going to get what? So, you know, the focus changes over time, but I think you're never too young or too old to do estate planning. And I think also it's important to revisit it at, maybe you could say, every 3 years, every 5 years, or even just when something important in your life happens. You get married, you get divorced, your spouse passes away, your child passes away, God forbid. You know, big life events are points when your estate planning should be given a look.
Okay, that's a good point. So something just popped in my mind. So if you have, say, one of these documents, you went to an attorney, you had this all put together, and then you wanted to make a change to one component of it. Do you have to go back to the attorney to get that done, or do you have to? You can do it yourself. I don't know.
Well, it depends on what you're going to do. If you, for example, let's say you want to change the person who you're naming as your agent under the power of attorney, then essentially what you're doing is revoking the old one and creating a new one. And in that case, yes, you should go to the attorney. I think you should always at least talk to the attorney. Sometimes maybe the document will almost do it automatically. Like, for example, if you say, I name my husband as my agent and my husband passed away, what do I do? Well, maybe the document automatically names your daughter as the backup, so then you don't have to create a new document.
Right.
So it depends on the circumstances.
Wow. Yeah. Wow. I'm so happy that you came.
I'm glad I can educate you and all our viewers.
Yeah, definitely, because this was very helpful in terms of clarifying the alphabet soup and all these terms that we hear, right? But this was great to be on a more serious note. Is there anything closing remarks you want to make?
I think that this can all sound very scary, and I don't think it has to be. I think that it's part of being a responsible person and a responsible adult, the same way that you pay your mortgage bill every month. Sit down, have a conversation. You worked really hard to gather all of your money and your assets and your lifestyle, and you should be in control of what happens at the end.
Exactly. And so if our viewers are interested in speaking with you, or they heard something here that they wanted, how could they reach you?
My firm has a website. It's lindabury.com, and you can call us. So the phone number's on the website. You can send us an email through the website. The internet is amazing these days. Just type in Lindabury and you'll showed up. Type in my name and you'll find me. But I think it's really important to speak with a lawyer when you're doing these things, because there are a lot of nuances that a will form that you might find on the internet isn't necessarily going to address. So it definitely is worth your time and money to do it properly.
Perfect. Thank you so much, Elizabeth.
You're
welcome.
I
really appreciate you being
pleasure.
here.
Thank
Likewise. You. And to my viewers, I want to say thank you again for tuning in, and I hope you learned as much as I did today. Until next time, think positive. And we're through.